one issue throughout these conscience debates is, of course, the difference, if any, between claims of individual conscience and claims of institutional conscience. I'm sure many of you are familiar with there's a roiling debate right now in the country, in both in litigation and at the sort of statutory level, about these pharmacist conscience provisions, right? The number of pharmacists, especially since Plan B, which is, you all know what Plan B is, once the FDA agreed to allow Plan B sales, the issue became that many pharmacists objected to filling these prescriptions. And so the question in a number of states, including this state, actually quite notably in Illinois, has become whether or not pharmacists should have those opt-out rights. I'm sure you're probably in your own work, and look forward to hearing about it in Q&A, familiar with perhaps physicians' claims of individual conscience in the clinical setting, refusing to provide care for abortion or the like. And so in these cases, of course, one of the interesting questions, and John Hart has actually spoken and written eloquently about this, one of the interesting questions throughout this debate is the role of the physician and the role of the patient, right, and what that relationship means, and if the physician should be able, notwithstanding his or her professional role and responsibility, in which he controls the prescription pad, controls access perhaps to some service, whether the physician should be able to, as a matter of conscientious objection, withhold that from a patient, then whether there's a requirement to refer or the like. In the institutional setting, of course, these same issues arise. I mentioned the Catholic Charities case that involved a social service agency, but I know that these same issues are arising throughout the country with respect to Catholic health care as well. It's arisen, I know, recently with respect, again, to Plan B administration. I gather there's some internal debate within Catholic health care about whether or not the accommodation that was reached in New York and Connecticut and other places with respect to Plan B administration is adequate. But again, you had in those states you had requirements that all hospitals provide as part of the standard of care for victims of sexual assault, certain care, and there were objections to that. And it was clear, of course, in the wake of Smith, Catholic Charities case and the like, it's clear that the religious institutions are almost certainly going to be unsuccessful in any challenge to these. And so that's sort of where the state of the question is now. And again, there's both this individual conscience aspect and then this institutional aspect. And I just want to say a couple things about that, this point about institutional conscience, which I think is kind of interesting and complicated. For so long, our tradition has thought of conscience as sort of this faculty up by the pituitary gland, right? That it's sort of this voice, this moral voice that speaks to the person and tells you what to do. And more now we're seeing, of course we have these pharmacist cases, many other physician, healthcare worker cases, but more and more now, as the Catholic Charities case illustrates, we have these claims of institutional conscience. And I think there's a lot of work that could be done and needs to be done in Catholic healthcare and thinking about the Church's mission and ministry, to thinking about what it means for an institution to make claims of conscience, what it means to have, as following on Father Himes this morning, what it means for an institution to have a distinctive mission and identity, and then to be able to speak in public about what that mission and identity is, and how requirements that the state is imposing might pose a threat to conscience. Just again, a few other concluding thoughts on this. I know that for many of you, there'll be familiarity with the way in which these cases are being addressed in much of Catholic healthcare now, and that is through the traditional use of the principle of cooperation, right? This idea of cooperation, material and formal, and proximate material cooperation and the like. But that this is one way in which I think the tradition helps to bring some wisdom to a question like this, but mostly, of course, as a way of allowing Catholic institutions to reach some accommodation with what the state has decided to require. More importantly, I think, is that we need to do more in Catholic healthcare and Catholic institutions elsewhere around the country about invoking doctrines like the freedom of the Church, which is an ancient and venerable idea, both in American constitutional law to some extent. There's this idea of church autonomy, as I mentioned before, that the state is incompetent to interfere in the internal matters of a church. But of course it goes back much farther than that. There's a famous chapter in John Courtney Murray's 1960 book, We Hold These Truths, called Are There Two or One? And the point Murray is making in that essay is that, that the insight of the ancient Western Christian, but not exclusively Christian tradition, is that there's the state and then there's the church, and that there's dual authority. And he says that one of the problems with this is Murray, is one of the problems with the modern world is this tendency to reduce everything to what he calls political monism, so that it's just the state. And notice that's exactly what's going on in many of these cases, right? That rather than allowing there to be variation and pluralism with respect to the delivery of social services or health care or education, there's an insistence that everything be flattened out, right? That rights of conscience, rights of sort of institutional pluralism be subliminated in favor of one-size-fits-all approach. And I think that in Catholic institutions we would do well to, where we can, to emphasize our distinctive voice in American pluralism and how rights of conscience and claims of conscience are a distinctively Catholic contribution in education, where I work, for example, in a law school and Catholic university, and in Catholic healthcare as well. Again, following on Father Hymes's point about sacramentality, that Catholic healthcare, just as it can be a sacramental witness, as it were, to the rest of the world of healthcare delivery, so also on a question like conscience and institutional autonomy, it can say that not just that we, sort of, it's this pituitary gland function that's whispering in our ear telling us not to do something, but that instead it's part of our identity is, for example, to be pro-life. And there's a lot to be said about what that means. And that efforts by the state to refuse to allow that, right, to impose requirements without rights of conscience to exempt oneself from that, are politically not just inappropriate, they're constitutionally inappropriate. Because as Murray says, there are two, not one. There's a separate authority to which we are answerable, and it's not just merely the authority of the state. And then finally, this is actually kind of an unwelcome note in some ways, but the other constitutional doctrine that we have some maybe hook with respect to is freedom of association. But again, it reflects a certain kind of individualism in the way in which American law and policy approaches these questions. That the one sort of novel First Amendment type argument that's gained traction in the last few years has been in cases in which groups have claimed rights of freedom of association to exclude unwelcome or unwanted messages, Boy Scouts versus Dale being the most famous example of that. But again, that's because the view of the court in those cases is that, well, that's because a bunch of individuals have decided to get together and they want to be able to exclude people on one ground or another, and that this is a First Amendment based on basically the right of freedom of speech. This is a protected First Amendment right. But I'd like to think that in Catholic institutions, it's not just that we happen to have a bunch of Catholic hospital administrators, nurses, physicians, and other healthcare professionals who happen to get together in a Catholic hospital and now have a freedom of association to be able to control their message, which is how the court usually styles these freedom of association cases. It's something much more central and important to who we are as Catholics, that we have healthcare institutions in the first place, and that freedom of conscience should be protected not so much based on a haphazard collection of individuals wanting to have a certain message, but because it's about who we are as a church and as a people and as healthcare institutions. And so with that, I'll leave off and then invite some conversation and questions.